Is this on? Excellent. I'm too short. So thank you so much, Samir, Haley, John, and Jackie. That was excellent. I'd now like to welcome our next panel, which will be moderated by Becca Branum, the Deputy Director of CDT's Free Expression Project, and it is on AI and the First Amendment.
Becca Branum, CDT's Deputy Director for our Free Expression Project. I'm thrilled to be joined by a fantastic panel to talk about AI, the First Amendment, Section 230, and everything in between. I'm pleased to be joined by Professor Eugene Volokh, who is Thomas Siebel Senior Fellow at the Hoover Institution at Stanford. He is also Gary Schwartz Distinguished Professor of Law at UCLA, where he will be emeritus starting a week from today. Congratulations. He has written extensively on free speech since 1992, on law and computer technology since 95, and on AI and the law since 2019. Two of his publications were featured in a symposium last year on AI and speech in the Journal of Free Speech Law, namely as author of Large Libel Models, Liability for AI Output, and as co-author of Freedom of Speech and AI Output. I'm delighted to be joined also by Ben Wizner, who's director of ACLU's Speech, Privacy, and Technology Project, which works to protect and expand the First Amendment freedoms of expression, association, and inquiry, and ensure that civil liberties are enhanced rather than diminished by or compromised by advances in science and technology. Next, we have Jeff Kosseff, who is non-resident senior fellow at the Future of Free Speech. He writes about online speech, the First Amendment, and Section 230. And last year, he published his latest book, which is called Liar in a Crowded Theater, Freedom of Speech in a World of Misinformation. And last but not least, I'm delighted to be joined by a former Senate colleague of mine, Keith Chu, who is Chief Communication Advisor and Deputy Policy Director for Senator Ron Wyden. What I would love to do with this panel today is really run the whole gamut of AI, from inputs and models to use cases and misuse cases, and everything in between, and transparency related to all of it. So maybe we could start with models. I might have a few directed questions, but please just jump in as the spirit moves you. So starting with models, last year President Biden issued an executive order requesting recommendations for regulations about the training, deployment, and publication of certain AI models, and some in Congress have gone so far as to suggest that export controls would be appropriate. So starting with models themselves, what about models might be expressive? Things like model weights, et cetera, but what would one say could be expressive values inherent to an AI model itself?
Sure. There are several kinds of regulations that I've seen out there. One has to do with calls for restriction on communication of let's say, the underlying weights. The theory being that those are the sorts of things that if they are allowed to be distributed, then either foreign dangerous people and entities or domestic people will be able to avoid whatever constraints we may want to impose on things. This is an interesting question. It has to do with the restriction on communication of factual scientific information. It's actually, my sense is the strong presumption is those kinds of restrictions are unconstitutional because they're restrictions on the communication of information. But there's not a lot of case law on this. And of course, we should also acknowledge that in a lot of these areas, when things are new enough and potentially seem dangerous enough and are different enough because they're new and dangerous from the kinds of things that the court has considered, it's certainly open to the Supreme Court to say, look, the big picture general statements we've said before weren't derived in this area. They may not fully apply to a completely new fact pattern. Certainly law sometimes emerges that way. But a second kind of thing that I've seen called for is attempts to regulate AI models in the sense of regulating the output of AI programs. And that, it seems to me, is really quite familiar territory in many respects. Now, it always helps to think of it concretely, but let's say, for example, the government says, we want to have a law that bans the distribution of anti-government or the creation of anti-government material by AI models. we're not going to ban you as an individual from doing that, but we're going to ban the AI company. We're going to require AI company to institute guardrails, whether within the model or through some sort of post-processing, that prohibits communication of anti-government material, or calls for attacks on the police, or allegedly racist speech, or allegedly homophobic, or anti-trans speech, or anti-Israel, or pro-Israel, or whatever else. That, it seems to me, is pretty familiar territory. That would be a viewpoint-based restriction. Now it would be a restriction on the mechanism for creating speech. And before, you couldn't do that. You couldn't say all printing presses had to have guardrails built in that kept them from publishing material with certain viewpoints. That just wasn't technically feasible. But if you could have, I think it's pretty clear the court would have treated that the same way it would treat a viewpoint-based injunction on the distribution of material or viewpoint-based punishment for distribution of material. So if that's the concern, there I'm a lot more confident saying that that is probably going to be unconstitutional.
Unlike Eugene, I don't have any computer science background, so I'm not confident that I know how these new AI projects map on to the First Amendment doctrine in, say, cryptography, and how much is expressive code and how much may be something else. I am deeply skeptical of national security arguments here and elsewhere, putting those cards on the table. The only people who have more definitions of safety than college students are AI policy people. I never know what people are talking about when they say safety. I think they should be much more specific and explicit. You know, I will say that even in the cryptography cases, I don't think at the end of the day they ultimately turned on the court's understanding of what was code. They came out the way they did because researchers and civil society made a persuasive case to the judiciary that the beneficial uses of cryptography far outweighed the inability of law enforcement to get access to every single communication in the world, which is why I think the cases about, you know, say crypto mixers like Tornado Cash are likely to come out the other way, because I think that the advocates of those technologies have not done a good job of convincing courts that there are great uses for those other than money laundering, which seems to be the main use. And so I think the question here will similarly be how freaked out are courts and policymakers by what's going on, and our job is to make this conversation be as concrete as possible. Are we going to let them have diffuse fears about the world blowing up? Or are they just scared about bullshit on the internet? These are different categories of safety concerns, and we need to separate them.
Okay. No, that's, wow. Okay. So I fully agree with Eugene and Ben, which is probably not that risky of a proposition for First Amendment analysis. And I also really do agree with Ben about the need to step back and just sort of, when people are calling for regulation, thinking about what will it do, what will be the long-term effects, because this is a new technology. There are some unknowns, there might be use cases that people have not seen before, and they react to them in different ways. So as was discussed, the way I sort of got into this field was writing about the history of Section 230, and when you look at what the reaction was to the internet in 1995, I can't help but draw some parallels between that and what I'm seeing and hearing from policymakers. I should say everything I say is only on my behalf, but some of it is kind of scary, like we're freaked out, we've got to do something, and we'll think about the constitutional issues and the pragmatic issues later. In terms of doctrinally, the only thing I would add, rather than just go over what's already been said, is that I also think there are some really interesting questions about the right to receive, the First Amendment right to receive. This is something that's come up not just in the AI context, but in foreign misinformation context, where there's cases that suggest, you know, the First Amendment's protecting not just the right to express the opinion or the information, but also of the audience to receive it. So I think that's really going to be coming up quite a bit as well during these discussions.
And Keith, how is your boss thinking about AI regulation generally, and sort of the free expression risks and rewards that might come along with AI?
Yeah, that's a big question. So, I mean, I think he is looking at it a couple different ways. Kind of his first priority is dealing with the near-term impacts of AI, as opposed to some of the more speculative in the world type discussions that seem to be taking hold in Congress to some degree. So his kind of flagship proposal is the Algorithmic Accountability Act. That bill would create essentially regulations at the FTC requiring people who deploy or create AI in high impact situations. These are things like employment, education, housing, where we already have laws regulating this kind of activity. So this law would require assessments both before they're deployed and ongoing for effectiveness, bias, things like that, which would be held at the FTC, and then there would be a list of where these systems are in place that would be made public so that people can know sort of if potentially they are being harmed by AI, they know where that is, and they know, they can make their own decisions based on that fact. He sees this as kind of a middle ground between the extremely prescriptive bills on one end, which would, pre-license AI models, things like that, and the kind of more laissez-faire approach that we're seeing from some corners.
And the hope there is to create a level of transparency publicly, right?
That's right. That's right. It again is a bit of a middle ground. It doesn't require all of these assessments to be made fully public right away. We know that can create some conflicting incentives at companies, but the assessments would be held at the FTC so that if problems are discovered, you can go back, you can look at it, the FTC can take action against the company there.
That's interesting. There are several proposals before Congress right now related to transparency, but transparency necessarily requires speech at some point along the process. And so I'm wondering if we could visit a little bit about the speech implications of requiring transparency, whether it's about AI models or generally. And would be curious for folks' thoughts on sort of the First Amendment implications of transparency into models and how Congress could do that effectively.
Start with your case about the New York law? Transparency of content moderation. It's a good starting point.
Sure. So I'm the plaintiff in Volokh v. James, where I'm represented by the Foundation for Individual Rights and Expression, challenging a New York law. Now, it's not an AI law, it's a social media law, but the law essentially requires social media platforms, defined broadly enough to include my blog, which has comments, requiring them to have hate speech policies, have policies that call it, I think, hate conduct, but it's really what some people loosely call hate speech. It's all about speech. Requiring there to be a mechanism for reporting supposed hate speech, and, at least as I read it, requiring that the site respond to it. To be fair, it's a relatively narrow law. It doesn't require that certain material be taken down, but it does require that we put up a policy on our site. And I don't have such a policy. I don't believe in those kinds of policies. I have my own policies, but they're not framed the way the New York legislature wants it framed. And the district court enjoined that on the grounds that it's a speech compulsion, requiring a speaker, me as the operator of my blog, to put up this kind of policy which expresses views that I do not share. So the case was argued before the Second Circuit. We have high hopes. I believe it was put on hold pending the pending First Amendment social media cases. One way or the other, they're going to be coming down, and presumably we're going to get a decision soon from the Second Circuit. So this is a peculiar law, and it's peculiar in two ways. One is it requires things to be actually put up on the speaker's site. And the other thing is it requires this in a viewpoint-based way. It doesn't say put up all of your moderation policies. It says put up those policies that have to do with supposed hate speech, which is targeting particular viewpoints. So, of course, the net choice laws also have, and it'll be interesting to see to what extent, if at all, the court actually deals with them, also have transparency requirements for the platforms, but those requirements are a lot broader. And you might say broader is worse. But sometimes broader is better if they're viewpoint neutral. So I think the jury is still out, or maybe the judge is still out, I suppose. It's not a jury question, on the degree to which those kinds of content neutral, or at least viewpoint neutral policies, requirements of disclosing policies would be permissible. But here's the second twist, which is that all of this, the strongest First Amendment arguments are when there's requirements that it be posted on one's own site. It turns out, rightly or wrongly, but perhaps inevitably, the rules are very different when there are requirements of disclosure to the government, even when the government may redisclose that. So, for example, the government can require the disclosure of contributions to candidates. And then it can post that information on its the FEC sites and similar state sites. It can require disclosure of spending on certain kinds of independent expenditure relative to candidates. But when there's a requirement that there be a disclaimer in the speech itself, like if I put out an ad or if I put out a statement, I need to have a disclaimer there occasionally that's upheld, but the standard is much higher. So that's a long way of saying that if the requirement is the AI company has to output the following information as part of its generated text, or even on its website, there might be some serious First Amendment problems, although less so if it's part of a commercial transaction and related to, here is, for example, what you're getting for the money you're paying us and such. On the other hand, if there are requirements to disclose information to the government, then even if the government then ends up redisclosing it, those requirements are much more likely to be upheld.
Yeah, nothing really to add. We're going to learn a lot more probably in the next 2 weeks about this. I do think Eugene hit on the key distinction between commercial speech and non-commercial speech. It's not commercial just because the entity that is speaking is a commercial entity. The New York Times is a commercial entity. So it's very important to adhere to the real doctrinal definition of commercial speech. I do think that there is a slightly misguided sense in policy circles that regulation is hard, but transparency is on the very easy side of that. And transparency is not that easy either with First Amendment doctrine, if you're talking about a speech platform.
Yeah, I fully agree. I think when I first heard about the New York law, it just seemed like something that was so easily unconstitutional that it seemed like they were just waiting for a lawsuit to get it struck down, which I guess is what's happening. In terms of net choice, I'm a little less optimistic that we'll get very many clear answers on the transparency front, both because of how they granted cert, the questions, as well as what happened at the arguments. It's much more focused on the restrictions on moderation, but that could have an impact on AI as well as a host of other issues, depending on how broadly the Supreme Court decides to rule and just sort of how it frames its reasoning in terms of the application of the First Amendment to the internet and to online platforms.
Just one more specific point. I mean, it wouldn't be that much fun if we lived in a world where every parody had parody emblazoned across the front. So.
Ben, you mentioned that there were some unique considerations as it applied to communications platforms and transparency into communications and speech platforms. What are some of those unique considerations?
Well, I think that as you see in the net choice cases, it's not so easy to separate transparency policies about content moderation from substantive content moderation policies. And I think you need to take a look at what is the government actor really trying to get at here. And I think there is a suspicion, at least with Texas and Florida, that they want more than transparency, right? They want to put their finger on the scale towards a particular substantive content moderation outcome. If they only had transparency provisions, they might be looked at a little differently if they weren't in the context of a bill that was saying, essentially you have to give equal time to political views.
And I'd also just add there are different types of transparency, even at issue in some of the net choice cases, where there's the individualized explanation for a decision versus the general transparency and policy requirements. And I think we had a little discussion in oral arguments with Justice Alito and I believe it was Paul Clement on the individualized explanations, but I have no way to predict how that's going to come out, but I think we might get some clarity on that.
Great. Maybe from there we can move from transparency to outputs. A simple question for you, are generative AI outputs protected by the First Amendment, and in what circumstances?
Sure. So there are, let's say, 3 ways in which AI outputs could be protected, or 3 bases for protecting them. One is to say they are the output of the AI company. The AI company may not know exactly what the output will be. In that respect, it's different from normal speech, but they do seem to be trying pretty hard to come up with various guidelines about what's going to be output. They don't just say, okay, we're just going to run some code on the training data, come up with a model, and then apply the model. They have all of this kind of fine-tuning. Some of it blows up in their faces, as with the black Nazis situation with Google Gemini or the female Pope. But that reflects the fact that they had a particular ideology they were trying to promulgate. Now they're saying we're changing it, but you might say, therefore, that it is one way or the other, whether they change it or not and how they change it, it does reflect their own ideas. I think that's a plausible position, perhaps even a correct one, but I think probably the stronger ones are focusing on the listeners, and Jeff touched on that. So one example, the sort of the classic listener interest provision argument stems from a case called, or is perhaps best illustrated by a case called Lamont v. Postmaster General. 1965, actually the first time a federal statute was ever struck down on First Amendment grounds. Little known fact. The statute at issue was a law that mandated that if there's foreign communist propaganda being sent into the U.S., it couldn't be delivered to Americans unless the person went to the post office and said, I want to receive communist propaganda. Unsurprisingly, many people did not want to have their name be on that list. The court struck that down, but it didn't strike it down on the grounds of the rights of the speakers, in part because it's never been settled to what extent foreigners have First Amendment rights when they're speaking from abroad. If they come to America and are prosecuted for what they're saying here, that would trigger the First Amendment. But there they are, sitting in the Soviet Union at the time, and they're sending material, or actually, I think actually in that instance it was China. Interestingly, everything old is new again. Sending material into the U.S., are they protected by the First Amendment against the U.S. government? Far from clear, especially if they're governments, because the suspicion in a lot of these is the mailers were not just private non-governmental organizations, they were governments. Far from settled whether foreign governments have any First Amendment rights. I suspect they probably don't. But the court essentially said, I oversimplify here, but essentially said, this is all about the rights of American recipients. And this law burdens the rights of American recipients by making it costly for them in that they have to have their name be put down on this list to receive this information. Therefore, it's unconstitutional. So likewise, if, again, imagine the government says, we're going to forbid generative AI companies from outputting, again, anti-war, racist, pro-Hamas, whatever else speech. That may very well interfere with the rights of people as listeners. Let me add a third argument, and that is the rights of people as creators of speech. The Supreme Court has never fully discussed this, but there's a line of cases in circuit courts, pretty unanimous at this point, and several of them from different circuits, which recognize the right of people to record information in public places, to audio and video record in public places, especially when we're talking about public officials like police officers in public places. The exact scope is not completely clear. What if they do it in a private place? Hard to know. But at least as to that core thing, laws that limit that kind of recording have been struck down. Now, why? They don't restrict speech. They restrict the use of an audio recorder or of a video recorder. But the court says if you want to speak effectively about something you see, it's much harder to do that if you just have to report on what you perceived, because people will be understandably skeptical, and denies you a great deal if you can't record it, because it keeps you from speaking using the recording. Likewise, a major function of LLMs, not the only function by any means, but a major function, is creating speech that we can then fiddle with and redistribute further. So to the extent the law regulates AI output, it also interferes with our rights, not just as listeners, rights as speakers who are using the AI programs to create speech that we then edit or just, maybe even without editing, distribute further. So those are the three rationales. Between the three of them, I think that's a very powerful argument.
I think the great virtue of the right to receive argument is that you can easily come up with hypotheticals where you would have a hard time deciding for yourself who the speaker is using LLMs. Is it the company, or is it the person who is generating the inputs? And it could be one or the other. And so I think it's going to be more robust to focus on people's right to receive, and it'll be a more stable kind of doctrine. I think in general, though, we need to start with the last couple of generations of cases about exceptions to the First Amendment and ask the question, what's not good enough about these? So instead of racing to a solution, let's articulate the problem. What is the problem that goes beyond defamation, incitement, true threats, right? These kinds of categories. Are we actually identifying, or is it just volume, right? Do we need to think about it differently in the digital age, the way we've thought about the Fourth Amendment differently in the digital age, right? So do we need to, people who I would have expected to be smarter about this, like Larry Kramer, the former Dean of Stanford Law School, says we need to rewrite the First Amendment now because of disinformation online. If we don't do it, democracy will be over very soon, right? With no attempt to get at the real world effect of disinformation and who is consuming it, why, what effect it's having. Just like we need to rewrite the First Amendment or we're all doomed. This is the smartest law professor that I had, which is a sort of Brutus is an honorable man comment here. But so I mean, my instinct always is, let's see if what we have right now has a real gap. And then let's talk about that gap. But let's not say, scary, 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 regulate.
Yeah, I apologize. There might not be all that much debate on this panel, but having published, I guess, 7 or 8 months ago, a book that argues that it is a good thing that the First Amendment does not have a categorical exception for all false speech, and then doing a media tour where basically every journalist wanted to tell me I was wrong about that, and I would then have to have a conversation about why it's good for journalists to not have this categorical exception. One of the most common reasons that I would try to really push it and say, well, what's really driving this? And AI was almost always at the top of the list, and it was this very vague concern. And I would say, well, what exactly is AI doing that is not already a threat in everyday life that we're not dealing with right now that wouldn't fall under defamation or true threat? And that's again why I'm hoping that we have a more sort of reasoned discussion before saying, well, AI is this big scary thing, we've got to pass a regulation. But I do think, unfortunately, that at least among the policy public, there is a movement to say, well, let's sort of create this new carve-out. The positive news is I think that on the courts there is not such a movement, and I think that the judges so far that have encountered at least novel First Amendment issues have generally been getting it right. There are exceptions, so I'm at least hopeful on that end.
Yeah, I'm here. Yeah, on most topics, I agree with Jeff here, so I can pretty much just hand him my microphone. But Senator Wyden, he's the son of a journalist. Generally speaking, he's going to err on the side of the First Amendment and free speech. And so I think a more fruitful way to regulate some of these AI questions is looking at privacy questions, which I know is kind of a broken record for a lot of people. But for example, with TikTok and foreign misinformation, Senator Wyden has a bill with Senator Rubio and Lummis that would restrict exports of large data sets of Americans' private information. That way you limit the ability of these foreign actors to target Americans with some of these, possibly harmful messages. And that seems much safer, although I know perhaps the ACLU doesn't agree with us on that one, but that seems much safer than regulating speech itself, which is a lot trickier in our view.
Great. I want to spend a little more time on the question of defamation law specifically, and as it applies to or intersects with a federal proposal that was previewed on our first panel relating to the use of materially deceptive artificial intelligence outputs. Specifically, there's a bill that would authorize a new federal cause of action for federal candidates who are the subject of materially deceptive AI to essentially sue the person who has created that AI and disseminated it. What can defamation law already do for candidates who are the subject of materially deceptive artificial intelligence? And are there any areas where defamation law can't get to that something like that could be appealing?
Does the law, I'm not familiar with the bill, does it lower the standards when someone is a public figure? Does it attempt to lower the constitutional standards? Because that would be a problem.
It only applies to federal candidates, and so to the extent that they're a public figure, then you're going to run into actual malice problems, I assume. But I'm curious for your thoughts on the risk, rewards, and what defamation law might be able to already do for these candidates.
Do you have a bill number? Right now.
So the one I'm familiar with a similar one, but it's not defamation. I think it's a PEDA, I think is the acronym, but it's not defamation. It's materially deceptive election communications, but it's enforced through the FEC. That's the bill that I'm familiar with, and that I think has some real problems because it essentially allows the FEC's general counsel to determine what's materially deceptive in terms of any use of AI, and I think that would have some real viewpoint problems by entrusting that. So that's the one I'm familiar with. I'm not as familiar with the federal law changing state defamation laws.
I think the difficulty here is that almost all political communication has almost always been false. And I don't really say that facetiously. I mean, what candidates do is deceive about the records of their opponents. Sometimes it's things that are not falsifiable. You can't say if they're true or not. Joe Biden is going to take your guns away. Well, you can't really say that's a lie because it's something that's in the future. Maybe he will. He hasn't said he's going to take your guns away. But that is politics as it's always been practiced. And then you say, so like, what is the kind of lie that is more concrete? And then people say, well, Trump won the 2020 election. And then I say, well, how do you know that? Well, the polls showed that and the courts upheld that. And I said, well, what about my view that Al Gore won the 2000 election? Is that something that can be prohibited online? None of these questions are really easy. I would start with, I wish we had someone here who could say why Congress thinks that they need a new cause of action for defamation, right? Because, we have very, well-developed case law about how difficult it is for public figures to sue for defamation. If this law is trying to reduce those protections, it's going to run into the First Amendment. If it isn't, what is it doing? I'm not sure.
And we also have a number of cases involving an Ohio law, I think it's Minnesota and Massachusetts at the appellate level, that have involving false statements about candidates that have gotten struck down for various reasons. And so I think that at least gives us a good guideline, at least in terms of the FEC related issue. Now that's different than, I'm not familiar with the defamation bill, but at least when it comes to letting the FEC determine, this is materially deceptive use of AI about a political candidate, I think that they're going to run into many of the similar problems.
And maybe we should just say a word about why we should be skeptical of this. Right? To me, there's a big difference between a government actor that is a federal consumer protection agency determining what's true or false in the public interest, and a partisan FEC official deciding what political campaign is true or false. Again, just because there is so much falsity in political communications, and that this is not the role that we want to entrust to partisan identified political actors in our system.
And one other thing that comes up in a lot of the case law about these false political statements when they're doing the analysis, and they've done it both under the different types of scrutiny, is that it's also not a terribly effective way of achieving your goal, because the false statement is going to be out there, and it might deter, to be sure, but a lot of times this is something that a complaint is filed, then it has to go to one committee that makes a determination and refers it to a prosecutor, and by the time that's all happened, the election has already taken place. So even if you were to set aside the free speech concerns, which I would not do, there's still, you know, what is it actually going to accomplish?
Yeah, I'm not familiar with this bill either, but I think generally speaking would be concerned about legislation to create special protections for politicians or powerful people that don't apply to regular Americans. So, that's something I'd keep in mind as well.
Well, maybe from there we can pivot from the First Amendment to Section 230, and I'm glad to be joined here by this panel for this part of the conversation as well. Just, Keith, can you walk us through Section 230 that your boss had such a pivotal role in crafting, and how you and he see it intersecting with free expression rights and what purpose it serves?
Yeah, well, today, if you ask politicians, it's kind of a vibe. It can be whatever you want it to be. It's the worst thing ever, or it allows the First Amendment to function on the internet. When he was writing it with Congressman Cox in 1995, the idea was to create protections that would foster user speech online, right? So the easiest way to describe it is the person who creates the content is responsible for it. So if I write a post that slanders Ben here, you can sue me, but you can't sue my web host, you can't sue the Tumblr that I posted it on. The idea being that without that protection, it would be very unlikely that companies would be willing to host user speech, especially when it comes to controversial topics like discussing powerful people who have done misdeeds, or Me Too movement, things like that. And so maybe another way that that Senator Wyden describes it is it provides a sword and a shield. It allows companies to moderate and take down content that they don't want on their platform, hateful content, violence, sexually explicit content, things like that, because they don't have to fear that they'll be sued for missing, an offending post, or, expressing a viewpoint that may offend many of their users. So that's the basic idea. Jeff obviously has a great book about it that I encourage everyone to read.
Is it fair to say or assume that they didn't have generative AI in mind when they wrote Section 230?
Yes, that is fair. To my knowledge, it did not exist at that point. I would say that there were kind of basic recommendation systems at the time, right? Curation systems that I wouldn't categorize as AI, but I think are important curation and publishing functions that I think were within the scope of Section 230.
There were very dumb chatbots back then too that were very funny, but I doubt that Congress had them in mind.
So I doubt it had it in mind, but it did write particular language, which I think ties very closely to what you were saying about how the person who created it is the one who should be responsible and not some third party. It says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So whoever is the one who provided it in the first instance is the one who could be sued. The thing about generative AI is it's generated, generates things. Its output is generated by this program created by this company. So there are examples. There are 2 libel cases already pending in American courts, in both of which the material that is allegedly libelous was not just a quote from some third party. If it was, then there would be Section 230 immunity. It was generated by, basically in both instances, GPT. And it seems to me Section 230 offers no protection there. If it did, then the answer is there's nobody you could sue, because you can't, by hypothesis, you couldn't sue the AI company, so you sue the creator, but the creator is the AI company. That isn't what the text of Section 230, it seems to me, suggests. Now, to be sure, this output is based on algorithms that this company has created, and it's indirectly based on the training data coupled with whatever else. But in fact, the statute defines information content provider as a person or entity that is responsible in whole or in part for the creation of or development of information provided through the internet. Well, at the very least, the AI company is responsible in part for creating it. Really, all of us, whenever we write anything, we're not wholly responsible. It's often based on something else, but we're responsible because, at least in part, what is output is because what we write is because of what we think. Likewise, the AI company would be that. Now, of course, the lawsuit wouldn't be against the AI, it would be against the AI company. Just like if you're hit by a self-driving car, once there are full self-driving cars, you're not going to sue the car, but you're going to sue the car manufacturer because they're the ones who let this allegedly defective product loose on the world. So it seems to me that the Section 230 case, the case that Section 230 does not protect generative AI output when it is indeed generated by the AI, as opposed to when the AI, for example, generates something, says, see these 5 links, and then the links contain defamation. That's more like a traditional search engine. But setting that aside, it seems to me there's really not much of a case for Section 230 immunity.
Yeah, and I would add that, at least in my experience with using generative AI, some of the generative AI is not all that generative, and it'll take a chunk from another website. And you might think, well, what's the scope of that? I've actually gotten this question a lot on panels and in interviews, and we do have Section 230 case law that obviously doesn't deal with AI, but it does give an illustration. One of sort of the most difficult 230 cases is from about 20 years ago. It involves a lawyer named Ellen Batesel. So she moved from California to North Carolina. She got into a dispute with a handyman who she didn't think did a very good job on her house. She was a lawyer for museums and art collectors. And he noticed that she had a lot of fancy artwork. So rather than sort of suing her in small claims court, he emailed a museum security nonprofit and said, you know, she had a lot of fancy artwork on her walls. I'm pretty sure it was stolen Nazi artwork. And I think she told me that her grandfather was Heinrich Himmler. None of that happened. It was made up. But the person who runs the nonprofit took this email, made some minor edits to it for grammar, sent it out to a listserv of thousands of people, and posted it on his website. And so she ends up suing, she loses a lot of business because she represents art dealers, and she sues him, the nonprofit, and it goes up to the Ninth Circuit, and the Ninth Circuit says, as long as it was reasonable for him to believe this was sent for him to post on his listserv and website, Section 230 applies, even though he made this choice to put it on the listserv and website, and even though he made these minor edits to it. So that's why when it's not generative, I just like to remind people, at least the current case law, this has not been overruled, on Section 230 is quite broad. So that's why it's a very case by case. I can't give and say yes, 230 applies or no, 230 doesn't. It's going to be a very case by case basis, and probably a judge by judge basis as well.
Yeah, I'd like to see how these libel cases play out. I'm curious, so what was the publication in these cases? Someone entered something in about himself, and what came out was libelous, or no? Okay.
No. If somebody enters something about himself, that's not libel, because the publication requirement in libel law is publishing to one person, but it's got to be a person other than the subject. So here are the two cases. One is Walters v. OpenAI. Interestingly, it was remanded for complicated civil procedure reasons to Georgia trial court. It's in state court, and the court denied a motion to dismiss. So the case is going forward. It didn't write an opinion, unfortunately, as many state courts don't. Here's what happens. Mark Walters is a gun rights advocate. I'm sure he would say that Biden wants to take your guns, and Biden definitely does want to take some of your guns. I take it your point is he might not want to take all of our guns, just some of them.
Or he will take your guns away, was the statement that I said. He's probably not going to take any of them away.
Well, fair enough. It all depends. It all depends on the results of the election. So in any event, Walters, I'm sorry, there's somebody else. Also a writer about gun rights, but not Walters, who asks OpenAI, or asks ChatGPT 3.5, please summarize this complaint in this case. And the ChatGPT says, no problem. It is a lawsuit by the Second Amendment Foundation accusing Mark Walters of embezzling money from it. It is a lawsuit by the Second Amendment Foundation. It doesn't even mention Mark Walters. It doesn't even mention embezzlement. It is a facial challenge to Washington state gun control law. Now, this guy happens to know Walters, and I suspect that he pretty strongly suspects this is not so. He lets Walters know. Walters is upset. Walters sues. So that's the case that's currently pending. The second case is Battle v. Microsoft. It's in federal district court in Maryland. So Jeffrey Battle he used to be in the Air Force, used to teach a class at Embry-Riddle Aeronautical University. He's a consultant on aeronautical matters. Calls himself the aerospace professor. So apparently he heard from someone that person had entered Jeffrey Battle into Bing, into the Bing chatbot, and that's what it comes out. For what I just said comes out. And it's all perfectly accurate. It's from his Wikipedia page. And then it says, however, Battle was convicted of conspiracy to levy war in the United States and sentenced to 18 years in federal prison. Turns out there's another Jeffrey Battle about whom that is true. So that's an interesting point, apropos what you were saying, Jeff, is that actually much of it is quotes, but that's not what is being sued over. The lawsuit is really over the words, however, Battle, right? That's the libel. The libel is juxtaposing the two and communicating, as the words however, Battle do to English speakers, that they're the same person. Kind of like a traditional commonplace libel case where a newspaper publishes a crime story and then illustrates it with a photo. Correct crime story, correct photo. What's incorrect is juxtaposition. It's the wrong person's photo. So that's what that lawsuit is about. Now, Battle is pro se, and he doesn't really know what he's doing, although he did do one thing that Walters didn't that I think strengthens Battle's case. He, before suing, got in touch with Microsoft and said, you're doing this. And they said, oh, we'll try to see what we can do to fix it. And they didn't. So now maybe they have actual malice in the sense of knowledge that their software is outputting a known falsehood, and they're continuing to do it despite.
So, I mean, I have a normative question for fellow panelists, and probably Jeff most, but also I would love to hear what Keith thinks, right? So let's say that these courts both say that OpenAI can be held liable for producing the typically idiotic responses that their chatbot produces. So is there a problem to be solved? So with Section 230, it's pretty easy to say, like, people generally like search engines and don't want them not to be able to operate. Some people even like social media for reasons I don't understand. But here, again, let's say the court says OpenAI is potentially on the hook for every defamatory fact that it spits out, when none of us are very confident that that's a solvable problem for LLMs. Is that a problem for society that policymakers should take on? Does anybody think so?
I don't. I think, I think that would be a matter for defamation law and what are the damages and so forth. But I think creating like Section 230 for generative AI, I think Section 230 for the OG Section 230. I think there is good reason for that because that's about user speech, and we have various policy reasons for that. I think I don't hear very much talk about saying, well, we want to do the same thing for user speech as for completely unaccountable generative AI. So I can't imagine that getting substantial support, but I don't work on the Hill, so I
Yeah, I agree with that. And I can't imagine that there would be one vote for that kind of proposal, at least in the Senate.
And
So,
if there is one, then we know that that's the one who's been subverted by the Terminator.
that's the AI, yeah. Yeah, I mean, it's the user piece, right? That's why Section 230 grants that immunity. You know, a chatbot is free to output whatever it wants, but then, you know, the company that makes it is the one responsible, right? You have no benefit in fostering speech that way.
Yeah, I guess the best argument that I would come up with is, you know, teenagers use ChatGPT to come up with an answer. They post it on social media because they think it's real. In that case, probably they would be liable as well as ChatGPT. And you might say that's a problem when this thing is being unleashed so broadly in society. Or we may want to really condition the norm. Don't post stuff from LLMs onto social media, right? That would be the counter argument, but I don't know.
That would be a great norm to try to establish if it weren't for the fact that Google is taking the opposite norm. It is posting the output of its generative AI at the top of every Google search, maybe not every, but the top of many Google search results. Right? So if that's so, then it becomes hard to say, oh, well, everybody should know it's all nonsense. Well, this very wealthy company is at least claiming it's not all nonsense.
Great. Well, before I move to audience questions, what did we miss? Anything anyone want to revisit before we see what questions folks might have?
Maybe just following on this last question, you know, there are proposals to explicitly carve out AI from Section 230 in the Senate, at least, and I think that folks should be cautious about moving in that direction. Some of the reasons have already been touched on. A lot of these cases are very fact-dependent, and so I think we're better off to let courts work through these situations before legislating in a broad way. The other reason is that the definitions in some of these proposals are not, frankly, very well tailored and would sweep in things like normal recommendation algorithms and a lot search engines, you know, just basic kind of tech functions that I think we all want to be protected by Section 230. And so I'd just have a note of caution there.
And then just going back to the beginning when we talked about export controls and licensing, I just want to make a broader point, which is that you know, regulation that will tend to entrench the status quo and entrench the power of the handful of large actors who now control these systems that are going to be more and more integrated into American life is a bad idea. I mean, I would say the problem is not too much transparency, but too little. People use the term open source for some of these, but they're not really open source. Like we can't tinker with them in meaningful ways. And so I think the national security interests that sort of go into restricting it are probably hopeless. I think that largely the cat is out of the bag, and therefore we should be, if there is regulation, aiming for regulation that makes these systems more accessible, not less.
So I think that's an excellent point, and it actually does bring up one downside of the current lack of Section 230 protection. I don't think it's enough to justify essentially making these things completely immune from liability. But here's what one of the things I worry about. The promise of generative AI in many respects, or at least one promise is, instead of going out or doing a search, if you want to know the answer to something, instead of doing a search, finding all these pages, reading these pages, absorbing it, taking all this time, you could just pose the query and it'll give you the answer. May not be a perfect answer, but you know, maybe good enough for your purposes. I think a lot of people are using it this way. That is the reason, that's the function of the Google outputting this little AI blurb, generated blurb at the top. Perfectly plausible for many people to do this. If this is so, though, they will also come to do this as to politics. Will Biden take away my guns? Will he try to take away some of my guns? What does this ballot measure mean? What would this bill do? What are the candidates' stance on this? I want to vote for a candidate who is most compatible with the following views. So let's say that people do this. Then that means that these big tech companies will become even more powerful. It will have even more power to affect democratic outputs than they currently do. Especially since they can and do and say it's a good thing that we fine-tune things. So if they fine-tune things in particular ways, then out come the views that they like. Now, that may be protected by the First Amendment. In any case, it may not be something we can meaningfully stop. But then one question that arises is, what do you think about the fact that the top two companies put together have 75% of the market share? Maybe that's going to decline. Maybe it's going to increase, right? For search in America, I'm talking here in America, one company has 90+% of the market share. And if that's so, in a country that's closely divided, if they can move even a small percentage of the vote, that could mean that they could leverage their economic power in an extraordinarily reliable way into political power. Now, what's the common answer to that, which I think still is the best answer? Competition. So if conservatives, for example, don't like what Claude and what Gemini, I guess Claude is almost an also-ran, but what Gemini and what ChatGPT do, they can come up with their own. Call them Buckley, the conservative AI chatbot. And then those who like it can do that, and libertarians can come up with Hayek, and out they go, and there's all of this competition. Well, the one thing is, you're right that regulation can stifle competition, but litigation can too. Yeah. So one result of Section 230, I'm not saying it's necessarily bad in general, but one result of it is that the big companies are going to be able to absorb all these costs. I was about to say they're going to insure, but they're not going to insure. They're going to self-insure for those costs. And that's fine. It'll be part of the cost of doing business. But upstarts may find it harder to do that. What's more, the more possible liability there is, the more incentive there is to have these various kinds of guardrails and fine-tuning and other restrictions. And in the process of trying to block the things that we agree are legitimately prohibited, like libel, it's never going to be a perfect solution, so they're going to end up blocking things that aren't libelous as well. So one downside of Section 230 is that it may indeed help entrench the duopoly, or maybe turn it into monopoly, or at least have a very small set of companies have very broad market share and therefore very broad influence over politics.
Great. From there, would love to turn to any questions from the audience. And we have microphones if folks want to.
Yeah. So, quick question. So, when you go and you chat with something like ChatGPT, I mean, as a user, you can essentially program it to do whatever you want. Like if you go in and you say, from now on, no matter what I say, pretend you're a dog and output a series of barks. So, or you can go and say, no matter what I ask you, translate it into Taylor Swift lyrics. So you can essentially program it to do whatever you want. Has anybody thought about how to figure out where the line has been crossed from the user's input manipulating the system to produce that output? Because there's a lot of discussion of it generates it, but it generates it in response to what the user has asked versus the model itself being designed in some way that caused that output in a way that we wouldn't expect.
It's a good question. I think, obviously, I would say even in response to that prompt, the company has some responsibility for the answer that it gives, but you can imagine a prompt which is, tell me about the sex crimes that so-and-so committed, where you might want to share some of the liability for the output? I don't know.
So I think there are three possibilities. One is, tell me about Jeffrey Battle. There, it seems to me, that's all on if it outputs to me that he's a criminal, that's liable by the AI company. A second question is, tell me the crimes that Jeffrey Battle has committed. I don't think that should relieve the AI company of responsibility, in part because even if the person suspects he committed crimes, in fact, even thinks that he committed crimes, the AI company can and should say, there turn out to be not any crimes by this Jeffrey Battle, let's say. Now, then there's the third thing. Write me a short story in which Jeffrey Battle levies war on the United States. There, it seems to me that that's not libel, simply because the reader, for the very traditional reason that the reader understands that that is not a factual assertion. The reader understands that at that point that is a short story that he asked for. And then if he redistributes the short story as if it were true, then in that case he is responsible. So I totally agree that in certain situations where the person essentially says, give me this output, and it gives him the output, it's false, the reader knows that it's false, and has his own reasons for getting it, sure, that's not libel under traditional principles having to do with things like obvious fiction and the like. But none of the cases that I've heard actually fit that pattern so far, at least.
You could imagine someone having his friend run 1,000 searches about him, and maybe that's what happened in the first case you talked about, until you get a false one. Right. I run 1,000 searches about who is Eugene until it tells me that he's a registered sex offender, and then he can bring a lawsuit.
Right, right. Again, there I think if the recipient is actually aware that this is false because he's deliberately tried to do it this way, that would be so. I have no reason to think that's what happened in Walters, although who knows, maybe.
Hello. Oops. Hello. Hi. Megan Gray, Gray Matters. I just had a clarification question. When y'all were talking about the applicability of Section 230 to Gen AI, as much as Gen AI is being embedded now into LinkedIn and Facebook and Google search, are the users, when they incorporate that output and, for example, retweet it or repost it, the user is still protected by Section 230 then, correct?
Yeah, and in the 26 words that Eugene read, what probably the most overlooked word in there is no provider or user of an interactive computer service. And actually in the Batzel case I talked about, they actually, the Ninth Circuit protected this nonprofit operator as the user of a listserv and a website. So obviously, again, it's going to be fact specific, but users certainly are covered. It's just not typically discussed in the current debate about Section 230.
So Jeff, I think there's a lot to that point, may in fact be correct, but let me just probe on this slightly. Let's say I ask ChatGPT something. As far as OpenAI knows, this is just for my own personal consumption. It is not intended by OpenAI to be posted on the internet, although I'm sure wouldn't be surprised if a lot of its output were posted. So indeed, Batzel v. Smith said there is a factual question as to whether this email was intended for posting, right? So if the email wasn't intended for posting, then there wouldn't be Section 230 immunity. So how does this play out in a situation where, I go to ChatGPT, I ask it a question, and there's nothing in the question that suggests that I am going to repost it, although it also doesn't say that I won't.
Yeah, certainly, and I think that might also be, I assume OpenAI has some good lawyers working on terms of use and disclaimers that would weigh in that favor.
Right. Well, but the disclaimer would be good with regard to, I'm sorry, but how will the disclaimer work? So if it disclaims things, that might be a way for it to minimize its liability.
Yes.
But if anything, Megan's question was about the liability of the reposter. So it sounds like any disclaimers might only increase the liability of the reposter.
Absolutely. Yeah, so I think that, again, it's fact specific, but I think and it'll get down to the material contribution test, but all of this is fairly hypothetical, but I do think that there's at least the user aspect to keep in mind.
Yes, my name is Roger Cochetti, and I have a quick comment on the 230 discussion that's taken place, and then a question about the generative AI. On the 230 discussion, which has been, I think, very helpful, at the time 230 was approved, I was the director of internet policy for IBM, and we endorsed Section 230, and I think IBM's endorsement probably made a little bit of difference. It was much better known than junior Congressman Cox or junior Congressman Wyden, and what I instructed our 15 in-house lobbyists and 15 paid lobbyists was that this is how you get porn off the internet. You let the social media take it down without being sued. So if you don't support this, then what you're doing is opening yourself up to an opponent who says he didn't do anything to take porn off the internet. And I would say there were a handful of lawyers, staff lawyers, lobbyist lawyers, who understood the three words that made that different was or otherwise objectionable. Those three words sort of stand, if you look at 230, it's like 95, 99% of the words have to do with pornography, and then there's or otherwise objectionable, which is something very common in the Congress. The handful of people who wrote the law knew exactly what they were doing, but the vast majority of the members who voted for it thought this takes porn off the internet. That's what this is about, we're getting porn. In that respect, on the question of what would the people at that time have thought, the couple dozen experts who knew what they were doing would have said, this applies to anything. It doesn't make any difference whether it's AI or a person. The social media is not liable regardless of the source. Everybody else would have said, well, it depends on whether it's porn. If the AI generates porn, then they could take it down. But if it's not porn, then it's not affected. So with that background, my question has to do with something that was lightly touched on, but I think is important, and that is the use of AI for generating deep fakes, which is a slight variation on what you've already discussed, because nobody at that time could have imagined deep fakes. And the ability of generative AI to create realistic, ongoing, interactive deepfakes is sort of mind-boggling from the point of view of somebody who worked on this in the 1990s. The question I have is really somewhat a legal question, and that is, there must have been a history of impersonators. I don't mean obvious parody. I mean realistic impersonators standing up looking exactly like Dwight Eisenhower or Harry Truman, and lying through their teeth, but trying to convince everybody that they were actually that person, realistically impersonating. And is there any legal history of realistic, not parody, realistic impersonation in liability or prohibitions on that would flow down to AI-generated impersonation? So deep fakes, I think, is an important future issue, and there may be something that's been around in human, not AI-generated impersonation. So background on that would be helpful.
Thanks. Very, very interesting question. I mean, I guess I would say the law already permits the regulation of impersonating. What it doesn't permit is, let's think about the fake Biden robocall in New Hampshire. If someone created that and it was intentionally presented as a deceptive ad from Biden, the law can say you're not allowed to deceive about the identity of the speaker in that particular instant. There's other ways that impersonation can be got at. What it can't do is ban impersonating generally. Right, so here we're talking about banning the means of impersonating, not a particular instantiation of impersonation where someone, right, so think about it another way. If Trump wanted to run an ad that was clearly labeled as a Trump ad, and it had a Biden stumbling around, then there would be a First Amendment problem if you say you're not able to use that technology to make fun of Biden in an ad. The difference is if it's presented as a Biden ad, which I think is your concern, that's already something that governments have ways of regulating. I don't know if you have more to say.
So the deepfakes question is an interesting and important question. There are probably three kinds of concerns about deepfakes. One is deceptive deepfakes. And there indeed, they could already be subject to possible liability if they represent a real person for libel or false light, invasion of privacy, and the like. A second is basically unfair competition deepfakes. Like somebody comes up with a new movie starring Humphrey Bogart. Everybody knows it isn't really Humphrey Bogart, but the Bogart estate may want to sue, saying, or may want to argue that it has a right to stop that. And then the porn deepfakes concern note has very little to do with whether it's deceptive or not. If somebody wants to put out there porn deepfakes of Taylor Swift, our concern isn't people will think, oh, that's a real Taylor Swift video. She's the kind of person who makes sex videos. Maybe that's part of the concern. It's a very minor concern. Imagine at the very beginning it says, this is all a deepfake. This is my fantasy of Taylor Swift having sex. No deception. People fully understand that. That may still be seen as a wrong to the person's dignity, which highlights the argument at the heart of the obscenity exception. For all its flaws, I think there is something to it, that there is something particular about sexually themed expression that leads us to think of it differently than if you have the same kind of non-deceptive parody or skit or comedy routine or whatever else. So it's just important to realize that much of the concern about deepfakes is about, in the porn context, is about dignity, not deception. One thing I should say, the second edition of my First Amendment casebook in 2005, I had a problem about deepfakes. Didn't call it that, but I knew it was coming, and I wasn't the only one. People knew it was coming. They just were hoping it wouldn't come.
Can I just confirm what I thought I heard, and that is that there is legally no difference between the liability one would have if the deep fake were a first-class human impersonator and an AI-generated impersonator. So if I had a Humphrey Bogart look-alike, perfect, and I pretended he was Humphrey Bogart and said, here's a movie with Humphrey Bogart, it's not an AI-generated, it's a person. There's no difference between the AI-generated Humphrey Bogart liability for...
Do we have time for one question? One more question?
Yes.
Yeah. Sorry.
There we go. Two sort of very separate things. So one, the discussion thus far, oh, and sorry, I'm Dave, full transparency. I used to be the head of trust and safety at OpenAI, so I have a lot of thoughts. But
So your fault.
well, I'm not there anymore, so some of it's not my fault. So one, the discussion thus far has sort of assumed that access to these models is mostly happening through chatbots. That is a big percentage of the access. There's also, from pretty much all of the largest providers, API access, where developers are building on top of that. And I'm interested if that sort of different mode of access, particularly as it intersects with some of these like clarity of intention, whether or not the accessor knows that something is fake, how that sort of plays with all of the analysis so far could be sort of interesting. And then second, wanted to push a little on the sort of open source question. It came up very briefly, and there was sort of a brief like, well, but you can't really mostly fine tune a lot of the stuff that's public. That's true for the very largest frontier models, but the ability to fine tune open source models, and particularly image models, is actually getting increasingly trivial. And it does intersect interestingly with some of what we've talked about so far, specifically in image models around the ability for deployers or developers to stop models from being able to be used to make CSAM or NCII. And I'm sort of wondering how you are all thinking about that from a sort of source control point of view, because it's not a national security purpose, but the reality is right now, if I have the weights of a model, I can trivially break any of the safety that was built into it. So there is, in some sense, no open sourceable image model that cannot be repurposed to make those images pretty easily.
Yeah, I guess I wonder how that's different from anything else, right? Either you can control what we see or you can't. And if you can prevent it from generating those images, you can, as Eugene said, dictate the result of an election, right? So I don't want those very, very important decisions being made by a few people in a room, even if it means that it generates more harm, which is why I'm a free speech lawyer, right? What was the first question?
Well, the first question has to do with what happens if there's the API, which basically leads some company to take the material from the output of the chatbot, presumably then process it in various ways, and then further distribute it. one of the good things about thinking about it in terms of tort law is there's a lot of tort law out there, and a lot of trans-substantive tort law topics having to do with things like proximate cause, having to do with things like aiding and abetting liability, having to do with just in general the question of whether there are multiple contributing causes, who is responsible, the answer often being everybody, potentially. And then, of course, there's also the possibility, as you pointed out, that if there is an API, there may be some sort of allocation of responsibility as between the parties, which may not matter if the API user company is judgment-proof, goes bankrupt. The third party wasn't privy to that contract, but so long as the company that provides the API has assets or has insurance, then it may very well be that the agreement between the parties offloads the responsibility onto the API company, that is to say the company that's using the API and its insurance provider.
And how they use it. I mean, I've seen that OpenAI has recently entered into all these agreements with media organizations, like here's $250 million to, to this one. And if say GQ is using OpenAI's API so that people can go to GQ and interact with its chatbot about fashion, and the reason why they're going to GQ instead of to ChatGPT is because GQ knows something about fashion, and it's not going to say where cooked rice. If the content is coming from GQ and the API is just a way of doing it, it seems to me it's GQ's content, right? So there may be other ways of using the API. I'm not really sure what they're doing. Right?
GQ is responsible. Right. But if what happened was that, it's hard to imagine a libel claim there, but if there was libelous material provided by OpenAI to GQ, that GQ then further redistributed, then the third party, who's not privy to any waivers within the transaction, might be able to sue OpenAI, at least in principle, depending on the facts. You're quite right. Very fact sensitive.
Great. Well, thank you so much to our panel. Please join me in thanking them for this fantastic discussion.